Good afternoon, everyone. My name is Brad Williams with the Detroit Regional Chamber, and I appreciate everyone having carved some time out of their Monday afternoon to spend time with us. I think many of you probably joined us the last time we did a webinar on this issue, and I hope there's a lot more smiles on your faces than there were the last time we talked about this. Of course, the legislature, got just under the wire to make a lot of needed changes to the Earned Sick Time Act. Our team had 5 different changes we wanted made to the act, and we feel like 4.5 of them were addressed by the bipartisan compromise that the legislature passed. So we feel like it was largely a win for the chamber, for our members, and the folks who are on this call. Before we get started, we have Sean Egan, who joined us last time, Deputy Director for Labor at the Department of Labor and Economic Opportunity. But I do want to take a second while I have everyone's attention to thank the members of the legislature who took on the task of tackling this issue. We had unanimous support from Republicans in both the Senate and the House, led by Speaker Matt Hall and Senator Eric Nesbitt. As importantly, we had 40% of the Democrats in both houses supporting the bill as well. As you might understand, the incentives for Democrats on this bill were different than they were for Republicans, with a lot of Democratic stakeholders asking the legislature to make no changes to this legislation. So I want to highlight a few of our regional Democrats who really took a plunge on this one. Senators Kevin Hertel, Veronica Kleinfeld, Jeremy Moss, Dana Paul Hankey, and Paul Voino from the region all voted yes. And in the House of Representatives, Albus Farhat, Noah Arbit, Kelly Breen, Brenda Carter, Tyrone Carter, Peter Herzberg, Matt Kolizar, Tullio Liberati, Joe Tate, and Karen Whitsitt. So if you are represented by a Republican member of the legislature or any of those folks, when you see them, make sure and say thank you because they really carried the load for the business community. And finally, thank you for activating on this issue and reaching out to your members of the legislature to impress upon them the importance of this issue. We recognize also that even though the legislation is passed and we think a lot of the issues have been solved legislatively, there's still a lot of questions as to how the implementation is going to work. And there's still some interpretation to be done by Sean and his team at the Department of Labor and Economic Opportunity. So with that, we are going to let Sean make a presentation. There is a Q&A function at the top of your bar. Please put your questions and answers in there. When Sean's done presenting, I will try and take all of those and put them into as many questions as we can answer. Please understand if I can't really get to the very specifics of your question, but I will try and group as many of them together as possible. And then we will try the questions that we can answer. We'll try and get some information for you. So with that, Sean, thank you so much for being here. We appreciate your time once again. I know it's a busy couple months for you with the implementation of this bill. So thank you. I'll let you talk and then we'll come back in a few minutes.
Awesome. Thanks, Brad. Happy to be back. And certainly if you joined us last Thursday, you're going to hear quite a bit of this over again, but I'm going to share my screen and run through a presentation that we'll be giving all over the state of Michigan to talk about the Earned Sick Time Act and minimum wage changes that happened. Now, one thing that Greg mentioned is it did get passed under the wire. What didn't happen, though, was changes in dates. There is one important change in a notification where there's a delay, but for existing employees, except for some small business stuff I'll cover, but for existing employees, last Friday, was that actually more than that, February 21st, the law went into effect. So people that are existing employees started accruing time potentially, or front loading needed to happen, or all those things are going. I can tell you that we are not out and about trying to find people that are trying to catch up with the changes in the law. We'll work with employers and workers to help employers effectuate the law. But key changes to the Earned Sick Time Act that happened was changes to the accrual method. So if you read the statute, the accrual method is the primary method for accumulating earned sick time The alternative is front loading, and that's an important distinction because of a few things that we found in the act. The other note I will give you is that as we're telling you these things or creating FAQs or whatever else, those are not law. They are just telling you how the department's going to evaluate a potential complaint that we receive. Some of these are right out of the statute, so clearly that is law. But when we talk about some of the FAQs, that's how we're going to evaluate the statute. And certainly if we find a violation, there are appeal rights and all that kind of stuff. So some of these things could change down the road. But the accrual method is the primary way that people get earned sick time. And for businesses with 11 or more employees, and we'll talk just real briefly about how you calculate that, employees would be able to accrue up to 72 hours in a calendar year. Actually, they could accrue more, but the employer can set a limit at 72. Now, if you do some quick math, if you work 40 hours a week, you don't get to 72, under 1 hour for every 30 hours work. For a small business, they can limit that to 40 hours, and the same is true for carryovers. And if the employer can limit any carryover of accrued time to 72 hours for the 11 or more, or 40 for less than 10 or less. There is a new hire waiting period in the law, and this is something we've been having a lot of discussion about because it appears that the waiting period only applies for employers that are using the accrual method. So if you're front loading, the time is available for immediate use. We did find what appears to be legislative intent from both the House and Senate that justify this position, and the only mention of 120 days in the statute for new hires is around, it says accrued, which front loading is not accrued time necessarily. So that is going to be one thing that you're going to want to pay attention to. Small businesses have until October 1, 2025. So if you're listening today and you're one of those 10 or fewer, you don't have to necessarily do anything until October 1, 2025. And then there's a 3-year sort of look ahead or look back from February 21, 2022 for small businesses, 10 or fewer, where they don't have to be in compliance for 3 years going back to that date. So if you started last year and you're 10 or fewer, you're going to have a couple of more years to come into compliance with the act. But for all other employers, February 21 is that date. You can also choose to front load. So this is something the employers really talked a lot about, was having clear language that allows them to say, hey, I'm a large employer. I'm going to give you 72 hours for earned sick time at the beginning of the year. You can track it in the same PTO plan. You can track it in a vacation plan. You can have it separate. You can do all those kind of things. But then if you do that, you don't have to pay attention to accruals. You don't have to pay attention to some of the other pieces. And then at the anniversary date, you don't have to worry about carryovers. So that is definitely an easier system for employers to use. It's the same for small employers where it's 40 instead of 72. And then you can front load part-time employees. Now, presumably, if they're salaried at 20 hours, let's say, that's your front loading. So what you're reading here or seeing here is more about part-time workers that are hourly employees. So you can make a guess of, I'm hiring Sean to work 20 hours a week, but there are going to be a certain notification pieces that you have to provide to that employee on kind of how you pick that number. And then occasionally you have to do what's called a true up. That's what people are calling it, where you're going to have to look and actually see how much I work. So if I'm consistently, you hired me, you thought it was going to be 20, and I'm consistently working 25, you may need to increase the amount of time that I have available to line up with that 1 hour of sick time for every 30 hours worked. You can definitely put it into an existing PTO policy or a vacation policy or something else with leave, as long as the total paid leave meets or exceeds the amounts that are necessary under the Earned Sick Time Act and may be used for the same purposes. So we talked about this under the prior language, which was a little bit more murky. This is more clear that if you have an existing PTO policy with, let's say, 80 hours, many of you are much more than that, but 80 hours, and to comply with this law, you say we're putting in 72 of those can be used for ESTA for the same purposes with notification requirements, family leave, all that kind of stuff. You've met your obligation. So if I choose to go to Hawaii for 80 hours, I don't have any ESTA left. You're still in compliance. And importantly here too is whether it's in a PTO bank or you're running ESTA as its own thing, the employee is requesting ESTA. So unlike the Family and Medical Leave Act that many of you are used to, where the employer sort of has to sort out when it's covered and make sure the employee understands that Under ESTA, the employee is requesting the ESTA hours. So one thing we hear about with PTO banks is, can I apply ESTA hours if an employee calls in sick? And the answer is, if they didn't request it, probably not, because it's on the employee to request the use of ESTA hours. If they don't request the use of ESTA, none of the ESTA provisions apply. So some of the discipline and other things that you do for absenteeism and tardiness would be your normal policies not related to ESTA. Hourly rate was clarified to say specifically it's your normal hourly rate or your base rate of pay. It does not include commissions, overtime, holiday pay, some of those other things. The department is solely responsible for the enforcement of ESTA. So any complaints would come to us. If there are those, we're certainly doing outreach and education as well. So feel free to get in touch with us. And then employers may choose. So this is an employer choice. The law is not that clear, but you can go 1 hour increments for use or shorter, depending on how you track other types of time or leave or attendance or something like that. But that's going to be at the employer's discretion. So your policy can say employees have to use ESTA in 1 hour increments. The only caveat I put there is, if I use ESTA, I call in ahead of the shift, I use ESTA and it's for 15 minutes, 30 minutes, something like that, and I go to work, they're likely going to be getting both, right? They're going to get paid as soon as they start working, and then they likely get that ESTA time as well. So you want to be mindful of how you do that. This act covers all employers in the state of Michigan except for the United States government. And then there's some exemptions for, well, not exemptions, but some qualifications for small businesses. And in the statute, it says specifically February 21, 2022, you have 3 years to comply. So like I said, if you started last year, February 21, you're going to have 2 more years before you have to be in compliance with ESTA. If you start a new business next week, you're going to have 3 years until you have to comply with ESTA, presuming you're under that 10 employee threshold. We did find one exclusion we shared before on federal law, specifically about railway workers and railway employers covered under the Railway Unemployment Insurance Act. If that applies to you, happy to discuss it, but that law preempts state sick time acts. There are some exemptions around employees, though. Generally, all eligible employees and individuals engaged in service to an employer are going to be covered by this act. Those employed by the United States government, pretty straightforward. Unpaid trainees or unpaid interns, individuals employed in accordance with the Youth Employment Standards Act. So if you're not familiar with that act, you don't employ minors, obviously you don't have to worry about it, but there are, if a young worker has a valid work permit or they meet one of the other carve-outs there on why they don't need a work permit, they would not be covered by ESTA. They would count for the number of employees, but they're not going to count for purposes of the benefit. And then one that probably the most confusion is coming around is this sort of oddly written, we think more narrow, but exemption of employees who they schedule their own individual working hours, and the employer policy, they can't take adverse action against that employee for not scheduling hours. When that was being discussed, it was there, the legislature was talking about highly compensated individuals. I don't have a great example, but they kept talking about surgeons who are technically employees of the hospital system, but in essence run their own practice. So the hospital may be their employer, but they're not really monitoring day to day when they schedule, when they don't schedule, what's going on there. What we do believe, though, is we've heard from employers who are flexible in their scheduling, but the employer still owns the schedule. So, but they allow employees to sign up for shifts and all those types of things. We do not believe this exemption covers those folks. We think it's really intended for you look like, you act like, you almost behave like an independent contractor, but you are an employee of that organization. So what we've said, we've heard from some various types of businesses where the schedule is posted on a website and I'm an employee and I sign up for a specific shift. The employer still owns the schedule. So that's probably not going to meet this exemption. And then we keep reminding everybody, publicly elected officials, a lot of your appointed commissions, things like that would not count as employees. Small business gets a little bit challenging. It's 10 or fewer. That includes full-time, part-time, temporary, seasonal, you name it. And it's over the course of 20 calendar weeks in your 12-month period. I didn't spend much time on the 12-month period, but you can choose that as employers. It can be anniversary dates. It doesn't have to be the same for everybody. You can have different groups with different things going on. The only kind of advice we give is I probably wouldn't make big variation within the classification, but if you have like salaried are going to be X and hourly are going to be Y, that's fine. And the way that you have to count employees, though, for purposes of that threshold is if you bump up, you have your seasonal shifts where you bump up and you have 11 or more for 20 or more calendar weeks during that 12-month period, you're going to be counted as 11 or larger for the remainder of that 12 months and the following 12 months. Just the way the law reads, just the way it works. Small business, I already covered. All other employers, February 21, 2025, people started accruing time, or you had to adjust front loading, or you had to do some different things. One of the big questions we've been getting is, if I'm on a calendar year and I've already given front loaded time off for individuals, what do I have to do on February 21? For us as the department, if we get a complaint, we're not going to be able to look back at what you did prior to February 21. So if you're putting it all in the same bank or whatever it is you're doing, all we're going to be able to look at is February 21 going forward. So if you're using calendar year, that's roughly 86%. Prorating is fine for this first year and for sure, and then new employees. That's roughly 86%. I think what we would look at is if you're doing 72, let's say that's somewhere around 62 hours. If you're front loading, that's what we would be looking for. Unfortunately, if you did 72 hours at the beginning of the calendar year and somebody took 40 in January, that's not something that we can look at or take into consideration. So we're really looking from that date forward, not that date plus a couple of months ahead of time. Certainly understand the challenges that go along with that, but as the regulatory agency, that's what we have to do. So that February 21. Now, new employees, it's on or after February 21, and that's where the waiting period can apply and all that kind of stuff. The waiting period is only for new employees. So anybody existing on February 21 or prior started accruing time immediately and it is available for use. One thing that did get shifted a little bit in the law is the 30 days for the notice. So under the law, very dense slide, but this is pulled specifically from the statute. There's a notice that employers have to give to employees. Maybe you've already done this. It's got all of those bullet points, the amount, how you're going to calculate the year, how it can be used, that you can't take retaliatory personnel action, that they have the right to file a complaint with the department. If you have other languages in your workplace, if it's 10% or more, you have to do that in that language as well. We create all these posters and all that kind of stuff in the department. We do translations as well. So if you're unsure, you should have access to multiple language resources. We typically do the big 4 or 5, which is common across state departments. We're happy to do more. We try to get as many different languages that are spoken in Michigan as possible, but we certainly focus in on those big 4 when we get started. Those are typically English, Arabic, Spanish, and Chinese. Sometimes French will fall in there too, believe it or not. So, but we have an updated poster right now on our website. You can download, put up, you're good to go with the poster, but you have 30 days from February 21 to get that taken care of. This is in our FAQ. The language around collective bargaining agreements changed from what it was previously to now. So it includes a specific provision that it applies to collective bargaining agreements basically effective immediately unless those collective bargaining agreements conflict with this act. What the way we understand the legislature's goal there was that if you've negotiated sick time language or whatever else similar, that it's your next contract. If your contract is silent, it's right now. So I know there's some groups that don't necessarily agree with that, but that's the way we understand it, and that's the way we're applying it. Again, this is just an FAQ. We still would have to make a determination if we received a complaint, and there would be appeal rights for that. Then finally, and I'll wrap up so we can get to Q&A, that I think we're all quite familiar, Michigan minimum wage was going to $12.48 on February 21 under the previous law. It stays at $12.48 on February 21 for the remainder of this calendar year. It'll reach $15 an hour by 2027, so basically a 3-year period. Next year will be $13.73 or something like that. We'll have that more specific, or we already do on the website if you want it. And then 15 in 2027. After that, it'll adjust for inflation every year. And then the tipped minimum wage stays at 38% for 2025, and then it starts a slow progression up to 50% of the regular minimum wage in 2031. So that puts the tipped minimum wage at $4.74 for the rest of 2025. Just a real quick on tips, all employers are obligated to pay the full minimum wage. Employers where they use the tip credit are allowed to offset their minimum wage obligation with tips that patrons receive down to that floor of $4.74 per hour. If they don't get to the full minimum wage, the employer is obligated to make up the difference. So it's very important that both the employer and employee are tracking tips, because if we get a complaint and the employer believes that the employee is making more than minimum wage and they're paying the 474, but there's no record to show that, we're probably going to have to make the employer catch up to the full minimum wage to offset that. Management cannot participate in tips, either through a tip pool or tips directly. And in Michigan, tip pools or sharing of tips has to be voluntary on the part of the individual that's receiving the tips. And there's some Fair Labor Standards Act stuff about spending 80% or more of your time in tipped activities. So it's a little bit complicated, but just the thing we always want employers to get out of there is management can't participate, and you have to make up the difference if the employee doesn't get to the full minimum wage based on the tips that they receive while they're working. So that was a real down and dirty, super fast presentation on some of the frequently asked questions that we've been getting, but certainly, Brad, happy to take and get to as many as we can today.
Yeah, I mean, Sean, I think we've got some questions that may be frequently asked, but I don't necessarily know the answer to them. So I'm gonna start with you. The one that's been frequently asked is this presentation available online, or can we make it available to our participants?
So I've shared the presentation with the chamber. They can certainly send it out. You can also find both what we did last Thursday and this presentation at michigan.gov/work wage hour. And under our ESTA link, it's posted there as well.
Okay, I am not the guru of IT at the chamber, but I will see if we can get this emailed to everyone as well. But if not, look for it on the Leo website. There is a number of questions here, Sean, about just clarifying if you have a PTO plan already in place. What does that mean in relation to ESTA? So, for example, says, just for clarification, if we provide 80 hours of PTO front loaded, we are covered under ESTA if we combined the two? Or can you confirm that if your paid time off is greater than what the ESTA law requires, then those hours accrued can be considered the ESTA hours accrued? Can we just clearly say what exactly how that works if you have a PTO policy that is or is at least as generous as ESTA, and what are the kind of requirements that an employer would need to hit to make sure that they're in the right spot?
Yeah, I think importantly in the statute, you can definitely use your PTO policy, but it doesn't mean that you're out of the ESTA umbrella completely, right? So as long as you're getting the large employer, let's just talk 72 hours in that PTO program, but the law says specifically that they have to meet or exceed the necessary amounts and may be used for the same purposes. And the statute actually says may be used for the same purposes as Section 4, which includes some of the notice provisions, some of the documentation provisions, as well as some of the definitions of personal or family or something like that. So my experience with employer PTO plans is they might have different notification requirements, or they might not be for immediate use, or they might require 2 weeks notice or something like that. So your time in your PTO plan can certainly meet or exceed the necessary amounts for ESTA, but you're not going to be removed from compliance with ESTA completely. And you're going to need to look at your PTO plan and figure out how you deal with shorter notices, maybe broader use, to deal with both that foreseeable and unforeseeable need for leave. So it's time-wise, you don't have to add more time. That'll probably meet or exceed that point of how much time is available, but you're going to want to look at that for the same purposes as ESTA.
So I have somewhat of a related question, and I think I know the answer to a lot of these, but I want to make sure that not being the one who's in charge of enforcing this, that I ask you. But it says, as an employer, do we need to track ESTA specifically requested hours, or if they request PTO, are we covered as an employee, even after they use their total PTO when they need to offer ESTA? My read is that if you have a PTO plan, you don't need to continue to offer ESTA hours. Is that, as long as it meets the requirements we just talked about? Is that correct?
I Well, you said offer ESTA hours. I think you meant track ESTA hours, right? If you have a
Right.
PTO plan. So I think the general answer is you really don't have to track much if you front load in a PTO plan. If you're using the accrual, it gets a little bit different. I think the challenge will become for us is it's a pretty easy example. If I had 80 hours and I went to Hawaii for 2 weeks, no ESTA left, nothing to track. I think it gets more complicated is if we get a complaint that the employee says they denied my ESTA use and it was because for whatever reason. I don't know that the employer needs to track ESTA use necessarily, but I'm just trying to figure out, we're just trying to make sure that when we get a complaint, the employer is going to want to be in a position that there's something there so that when we don't get to decide if we're investigating or not, right? We're going to ask the employer questions like Sean said he had 80 hours in his PTO bank. He hasn't used them all. You denied his ESTA use, whatever else. So I think we can work on that, Brad, but I think you're right. There's not a whole lot of tracking that has to happen, but I'd want to think about how we manage potential complaints that we may receive and what information the employer may want to have to ensure that there's something there. If the S hours are gone, that's really easy. I think it's a matter of if they still have time in their PTO plan.
Yeah, it seems to me, and correct me if you think I'm wrong, Sean, because again, you're the one enforcing the law, but at least early on, it would behoove employers with PTO plans just to make sure their record keeping is as strong as possible. And I would expect most people here are doing that already.
Yeah, and I think it goes along with, as I mentioned, maybe I did mention it, but for ESTA, the employee is going to have to request the use of ESTA hours. So I think you're definitely going to want to track those, right? That Sean requested whatever on Tuesday. But all the remainder is, to Brad's point, just kind of use your best judgment. That's not a good answer, but use your best judgment on other information. But I think that, whatever record keeping you want to maintain for ESTA purposes is valuable.
Okay. We've got a few questions that I think I can kind of group together. But what about staffing suppliers who are providing temp employees? My assumption is they still have to provide earned sick time, but are they able to bill that out to whomever they're providing the temp to? So if I am offering a temp, or if I have a temp come in and help at the chamber for a while, can the temp service bill me for the ESTA hours?
That is not something that we have any authority for. I would assume it's a contract issue, and however you manage that, I think is not something that we would have any oversight or regulatory authority into.
What about 1099 contractors? Are they considered employees?
No. So as a true independents, we always say true independent because some people are misclassified, but if they're true independent contractor, they're not the employer's property.
We have a question here. This is an interesting one that I thought of. Does this law apply to an Ohio employer where employees are making deliveries into Michigan?
Yeah, it does. I think it's for work hours in Michigan. I think it gets a little bit hairy or challenging in that situation on the amount of time that they might be making deliveries into Michigan. But if you're an employer, a Michigan employer, your employees normally work here and you send them to Ohio, they're not accruing ESTA while they're in Ohio, nor would you have to let them use it in Ohio. But we wouldn't consider that a break in service for purposes of the 2 month and everything else. But conversely, if you're an Ohio employer and you send folks to Michigan to work, they're gonna be covered by ESTA, and they're gonna accrue time under ESTA.
Yeah, it seems like there's an Ohio joke in here somewhere, but considering this person's probably a chamber member, I probably won't make it. But um, okay, what about the increments that folks offer their PTO in? I know you talked about hour-long increments. Um, if they offer a PTO plan currently, so for example, at the chamber, I can either take a full day off or a half a day off. If you offer a PTO plan, do you have to offer it in hour increments, or is that just for people who are using uh, ESTA hours, as we call them?
Uh, when you say S hours, you're talking about the accrual method
Yeah.
versus a PTO plan? No, I believe that you would have to follow ESTA increments for even within your PTO plan.
So that may be one change for a lot of folks on this call from their current policy, just so you know. Um, what about front loading for part-time employees that have somewhat irregular schedules? Someone who maybe, one week works Tuesday and Thursday, and then the next week maybe works a full week because it's busier, and then the week after that might not work at all.
Yeah, the employer is allowed to sort of do their best guess if they're going to front load for part-time employees and then periodically do a true up. So if you thought it was going to be 15, so you front loaded based on that type of accrual, and 3 weeks later, it's you don't necessarily have to go that often, but a few weeks later, it's pretty obvious that they're working more than 15. You'd have to true up and basically say, hey, I front loaded X, but you're actually working more, so we're going to make it 40 instead of 30, right? Hours that we front loaded or something like that.
Okay. So let's talk about rollover requirements. In an instance where you have a PTO plan, it sounds to me like there aren't, and it's front loaded. It sounds to me like there aren't rollover requirements. Is
Right.
that true?
Yeah, correct. For front loaded plans in particular, and that's a good flag because you can use a PTO plan with accrual as well, as long as it meets the same accruals and all that kind of stuff. But for front loaded PTO plans, you do not have to allow carryover, sort of for obvious reasons, right? Because at the beginning of the next 12 months, you're loading it back up. So there's no requirement to allow carryover.
Okay, here's let's see. Let me find the question I wanted to ask next here. There was a lot of good ones, so I want to make sure we get to them all. Um, if someone hires someone in the middle of the year, say with 6 months to go in the year, may they use the accrual method for the first year and switch over then to a front loading in year two?
Yeah, we think so. I mean, there's nothing that would prohibit the employer from doing that, and there's nothing in the statute that says once you choose one, that's all you can do forever and ever. So it's going to be really the employer's policy. The only sort of uh, caveat we would give there is, your goal is compliance with the law, right? So if you're using accrual to get around the front loading 120 days or something like that, that could create some challenges. But I don't think that's a problem with that concept. You can also prorate the front load as well for that 6 month period.
What about someone who has student employees? And it sounds like this may be someone who works in a university town or maybe a university itself. If you have a student employee that takes the summer off, is that considered a break in service and you reset it each fall, or how long do they need to be out of on a break from their employer before it's considered a break in service?
Yeah, the language, I actually got some feedback from our webinar on how I talked about unemployment. And that means a separation because it doesn't always mean that. The the check there is going to be, are they still an employee, right? Did you lay them off with the intent to rehire so they are technically and actually separated from employment, or are they still on the rolls as an employee with 0 hours? I think that would make a distinction on whether or not that's a break in service. What I had said last week about unemployment is if you're collecting unemployment, presumably you're separated from employment, right? But there are temporary layoffs and other things in the employment statute that allow you to basically be considered an employee of the employer, even though you're not working. So there would be a distinction. If you keep them on the rolls as an employee, arguably that's not going to be a break in service.
Okay, so There's another question again. If you have employees that work out of state for just a few weeks at a time, I assume that that time doesn't accrue, right, while they're working. So if you've got if you're out of state for a conference or something like that, those weeks don't count for accrual purposes.
Correct. Yeah, we actually talked about sort of a de minimis deal on this issue. It's not in the, but it didn't make it to the statute because uh, that's correct though. If you're working for a Michigan employer and they send you out of state for work, you're not accruing time when you're out of state.
So one of the big concerns that I know we had and a lot of employers had in the law before we changed it was the 3 days off without notification. Can you explain what changes were made in that? And specifically, the question is about if an employer can still require a doctor's note when someone takes time off, and are they still required to pay for that doctor's visit?
Sure. So the law was changed on the notification part to allow the employer to establish a written policy on how employees have to notify. As long as you give that to the employee in writing, and if you make changes, as long as they have it 5 days prior to the application of the written policy on how they notify, the employer can specify different notification provisions. The big piece in the law was that concept of as soon as practical, and it was unclear what that meant. Now there's a B there, though, in the notification requirements in the employer policy that says it allows the employee to notify the employer as soon as they became aware of the need for leave. Brad, honestly, we're still sorting out what that means. It kind of sounds like you can have your policy, but you still have to allow a potentially less time. So if you say an hour before your shift and I didn't become aware until 15 minutes before the shift, then I should be allowed to give some kind of notice. Now, if you read the statute, all of that is just in the notice part. It doesn't seem to change the documentation requirements. So we still have, for those first 2 days, an employer cannot require documentation. For 3 days or more, the employer can require documentation. And still in the statute is if the employer does require documentation, the employer has to pay for it. And what we mean by pay for it is if you have a copay or deductible or whatever, the doctor's going to charge you to fill out the thing, the employer is going to have to pay for that.
This question is really specific to a company, but my guess is it probably applies to other people. And it says, we currently dump 40 hours into PTO on January 1st, and new hires get 10 hours per quarter when they hit their 90 days. So, for example, Susie started on May 1st. Her 90-day probationary period ends July 30th. And July 30th is the third quarter, so she would get another 20 hours dumped into her bag. So it seems to me that this situation here is when you're hired, you get 40 hours, right? Which is not the 72 that's required in the act. But by quarter, you get more time, so you eventually do, over the course of a year, get your 72 hours. That's one I hadn't even considered, but how would you look at that as the regulator here?
Yeah, so presuming that's a front-loaded method, I mean, it could be sort of an abbreviated accrual method, right? Where you're saying, hey, we anticipate you'll accrue 10 hours over whatever. So we're going to put the 10 in here for the first 90 days. It'll be available when you get there, all that kind of stuff, whatever. But the front-loading language is very specific in the statute that if you are front-loading, it's the full 72 or that prorated amount. So if you started in, I think you said May, maybe, and you're using the calendar year, you can prorate from May until the end of the calendar year, but it's pretty specific that it's the full time, the full amount of time that would be 72 for a large company or 40 for a small business. And then however you prorate that for when they started. So that 40 at the beginning, under the statute, probably has to be 72.
I think I know the answer to this question too, but and I think you've answered it, but if you front load an employee and they don't use all of their front loaded hours, is there any requirement that you pay that money out at the end of the year?
No, there's no requirement under either the accrual or the front loading method that you pay people out. There are some provisions that allow you to do that, but there's no requirement to do that.
Right. Here's another question that I think you mentioned during the presentation, but I just want if we could reinforce it. Um, if our PTO policy adheres to ESTA and an employee uses all 72 hours in our PTO for vacation and not for sickness, uh, do they have any more hours under the Earned Sick Time Act?
No, no.
So when you have a PTO policy, it's you can use it for the same purposes under PTO. So if the chamber gives me 72 hours and I go to Disney World, I better hope I don't get sick the rest of the year.
Yep.
Okay. Let's see. I've had a few more come in. I've gotten a lot of the questions that I highlighted during your presentation. Let's see. So if an employer has to cover the trip to the physician's office, does that include mileage, the cost of transportation, childcare, that sort of thing?
Our wage and hour folks are reviewing that because there are some similarities to the Paid Medical Leave Act and kind of how they applied that. I think the short answer is I don't know. I have heard discussion about mileage, but based on the statute, I think the intent was your copay and deductible, but our intent would not to be like broad beyond what would be reasonable.
Any thoughts, Sean? I have a question specifically on the transition between ESTA for building trades when the CBA expires and negotiation starts the next time. How would that transition work in your mind? And I know that may be not exactly top of mind because we've got maybe a few months before we have to deal with that. But have you thought that through?
Maybe most of what I'm hearing about for building trades is that many of their contracts are silent when it comes to earned sick time. And as we put in our FAQ, and the language that says if it's in conflict is that if it's silent, then February 21 was the date. So I know that some trades, one thing we did get into these amendments as well, though, was language that makes it easier to use collectively bargained Taft-Hartley fringe benefit funds to provide this type of benefit. It makes some changes to the 120 days carryovers, employer to employer, and things like that. So those parties could definitely try to use those types of funds. They're pretty used to those. They use them in a lot of different ways for purposes of providing the ESTA benefit.
So the original act, Sean, you could earn up to 72 hours per year, and then you had to be able to roll over 72 hours per year, I believe it was, if you use the accrual method. Is that still in place? Do you have to roll over with accrual? And is there, in the previous act, you could limit how many of those rollover hours could be used in the preceding year? Is there a limit? Is there a limit still in place, and what is that?
Yeah, for the accrual method only, theoretically, the individual can accrue more than 72 hours, but the employer can limit use to 72, and they can also limit the rollover to 72 year after year. So if I didn't use any for year one and year two, presumably I'd have 144 hours, right? Year three, I'm still only rolling over 72. So that's only using the accrual method, though. Front loading, you don't have to do that.
Okay. So can you reiterate again what happens if you want to front load and someone starts, partway through the year? This question specifically is November. I'm assuming they might function on a calendar year, but if they have, can you explain prorating and how that's
Yeah.
allowed again?
Yeah, we understand that employees will start throughout the year, and for this example, let's say you're using the calendar year, whatever your 12-month period is. If I started in November and my calendar year is January, you can certainly look at that and determine how much time that is for the course of a calendar year. So what we did, you don't necessarily have to do it this way, is we just took February 21 to December 31st with something like 322 days divided by 365 gets you about 86%. But however you kind of come up with that reasonable calculation of I started Sean on November 1, we end on December 31. So I'm only front loading whatever that is. Let's say it's 10 hours or 15 hours or something like that, to basically equal what a 12-month front load would look like.
Okay. Can you explain again, like with part-time employees, how you do proration too? So I'm
Yeah.
assuming the question is if someone works 20 hours a week, as opposed to 40 hours a week, do you have to give them 36 hours or 40 hours depending on what size business you are in your front loading?
Yes. Yeah. If you hire a part-time employee, let's say they're hourly, if they're salaried, 36 would be it, right? Because you're salaried at 20 hours a week, you're kind of all done. But on those hourly folks, you hire them for 20 hours a week, you can take your best guess on what you expect them to work and front load based on that guess. You just have to check in from time to time to ensure that you didn't shortchange them. So if you hired them at 20 hours a week and you gave them 36, some point you're going to evaluate and say like, well, Sean actually worked 21 hours. I would actually be a little bit ahead of that 36-hour accrual or something like that. So to your earlier example, Brad, is they hired me for 20 hours, or I worked 15 this week, a full week the next week, maybe 15 again. You can kind of just true up from time to time what you front loaded versus what's actually happening based on that one for every 30 hours worked.
How often do you recommend people true up? Is it a monthly process, a quarterly? What would you suggest?
Yeah, I would suggest that if you're doing that on the hourly folks, that you probably take a look at it monthly to start. I mean, if all of your employers know their business pretty well, and if they know that it's not very often that I'll work more than 20, maybe it could be quarterly. But for employers that fluctuate quite a bit, I would guess the service industry where, things can change really, really fast. Um, they may want to do it on a monthly basis. The goal there, though, is you just want to true up, catch up on kind of if you front loaded and it's too low, you want to make sure that you catch up. Because if we get a complaint that says, hey, they front loaded me 20 hours and I should have 35 and they're not letting me use them, like that's a challenge, right? So I would encourage employers where they see big fluctuations in the number of hours to maybe more frequently. For employers that are used to more consistency, maybe less frequently.
One question that came in earlier that I thought was a good question, and I just forgot to ask it. I'm assuming this is a manufacturer and they pay employees by piece rate, as opposed to an hourly rate. So would they use the hourly rate for minimum wage and ESTA purposes or the piece rate?
I think the way the statute clarified it would be the full minimum wage.
Okay.
Where we say normal hourly wage or base rate, what that really is talking about are people that may be paid differently for different work that they're performing. So I know piece rate does that, but for this particular job, I'm at 15. For this one, I'm at 13. We actually do see this from time to time. So that normal hourly rate gets a little bit weird, but for piece rate, I believe it's the full minimum wage.
What about commission-based employees? If you don't want to front load, do they have to submit their hours worked? So if you're out on the road selling widgets, um, do those employees need to report back, hey, I was working for 10 hours today, 6 hours a day before?
Yeah, potentially. We're still talking a lot about commissioned employees because there's such a variance in how they're treated in different industries, to try to make sure we get it right. So um, I think the answer is yes, but we're still working out kind of how that might look in different places. And then the full commissioned employees where the employer is not paying attention to anything they do are one of the groups that we think might fall into that exemption.
Okay. So how about there's a question here again. I know we've talked about staffing companies once, but here's another question for them. So a temp assignment ends, but the employee's not working, not receiving hours. If you're not going to front load, they're still an employee, right, of the temp agency, but they're not receiving hours. If you're going to use the accrual method, what happens in that time when they're not using hours? And does that impact their separation of service time as well?
I don't believe under that example it would impact their separation of service. They're just a temporary employee without an assignment right now, right? They're still technically an employee of the leasing agency. Um, the hours that they've accrued will just kind of sit there until they're working again. You use ESTA for scheduled hours, so they can't really use ESTA hours in that in between period where they're not employed. It would be back when they're actually scheduled to work and all of those types of things.
Well, I think I have covered almost all of the questions, and if I haven't, I've covered them generally. The last one I have, though, is what about record retention? How long should people keep their records?
There's a 3-year statute of limitations on these for complaints and the 3-year record keeping requirement. One of the questions we get the most is, if I'm front loading, what records do I need? And I think to that point of um, how much time did you give? Did the employee request the use of ESTA? Were there denials of the use of ESTA? Those types of things you would want to keep track of. You don't have to get into how much they would have accrued. You don't have, I mean, there's a lot of things that you don't have to track if you're front loading, but you're still going to want to have some records there that the employee, your policy was updated. The employee had access to 72 hours. They used 10 of them, whatever, when they're requesting ESTA, if you track that, and just make sure you maintain those.
Great. Well, Sean, I just want to say thank you again. I know I've shared this privately, but both you and your team have been real champions on this issue. This was a real struggle from the very beginning, and every time we had a question, you've done your best to answer it. The FAQs that Leo has put up have been incredibly helpful. So I can't thank you enough for your partnership over the course of these last several months. And I just want our members to know that Sean and his team at Leo really are exceptional at what they do, and we should be thankful that we have them. I want to thank everyone again for joining us. This has been a real eye-opening experience for me, and hopefully for you. Hopefully you've gotten a lot of valuable information. Again, I want to emphasize, when you see your legislators, particularly if you have a Republican legislator, thank them and their leadership, Speaker Matt Hall and Minority Leader Eric Nesbitt. And if you are represented by any of these Democrats, Senators Kevin Hertel, Veronica Kleinfeld, Jeremy Moss, Dana Polhanke, and Paul Voino, or State Representatives Albus Farhat, Noah Arbit, Kelly Breen, Brenda Carter, Tyrone Carter, Peter Herzberg, Matt Kozar, Tullio Liberati, Joe Tate, or Karen Whitsett, thank them. Because there were a lot of political incentives for Democrats to stay on the sidelines here. But their action, while it wasn't as swift as we in the business community would have preferred, certainly saved us a lot of headaches. And as we continue to work through implementation of this act, look to the chamber. We will be updating you through newsletters, through blog posts, as there are changes not only in this other major business policies. The team here at the chamber is honored to be able to work on your behalf, and we look forward to continuing to do it. So with that, I will say thank you and enjoy the rest of your day, and we look forward to talking to you again soon.